Was there a leak? Was there an inadvertent release by the court's PR team on its Supreme Court website? A major decision was, at least we know, inadvertently dropped on the Supreme Court website. We're going to dissect what that decision was. It was not supposed to be released today, but it was released, and we can analyze what a major holding it is. This is the statement just put out by the Supreme Court. The opinion in the case Moyle versus United States, case number 23-726, and Idaho versus United States, case number 23-727, has not been released. The court's publications unit inadvertently and briefly uploaded documents to the court website. The court's opinion in these cases will be issued in due course. This is the case that relates to the Emergency Medical Treatment and Active Labor Act, EMTALA, and how that relates to the reproductive rights bans in place in a state like Idaho, and how the Biden administration's guidance to emergency room physicians under EMTALA to treat women with abortion care as a form of health care in emergency situations interplays with the basically extreme ban that they have in states like Idaho. In Idaho, they were saying that this law cannot be enforced. The Biden administration was saying, no, women have a right to emergency care. And now we've got what the ruling is going to be because of this inadvertent release. And we have with us, of course, Mike Sachs, MeidasTouch correspondent on all things law, politics, with a specialized expertise in all things Supreme Court. What's the ruling? How is it released this way? What does it tell us? There's a term called dig as well. Explain it, break it all down for us.
Yeah, Ben. So the vote here was to lift the stay that the Supreme Court had entered on a lower court blocking of the Idaho laws enforcement. That sounds like a bunch of mumbo jumbo, so let me put it to you plain. Right now, Idaho cannot enforce its ban on abortion when people come to the emergency room needing stabilizing care that a doctor in the emergency room says means an abortion. So Idaho's ban is not in effect for people who go to emergency rooms that need abortions and doctors say, I agree. This was an issue that came before the court because Idaho passed a near total ban of abortion after the Dobbs opinion came down 2 years ago, overturning Roe versus Wade and Casey versus Planned Parenthood, which, as we all know, guaranteed the fundamental right to choose an abortion under the 14th Amendment. All right, but this case came before the court, and people didn't know what was going to happen until today. In fact, we weren't even supposed to know what was going to happen today because someone in the press office of the court inadvertently uploaded the opinion, and Bloomberg Law, the reporters there, saw that, downloaded it, gave it a look, and put out a story for everyone to read about what the opinion said. And the big surprise in this case was that the court actually decided not to decide the case. The court could not come to a majority to say one way or the other whether the federal law EMTALA conflicted and therefore overrode the state law in Idaho's virtual complete abortion ban. And this was something that, at least an oral argument, seemed to be taking shape because you had three camps. People talk about this court being a 3-3-3 court, which I contest. It's 6 pretty right-wing Republican appointees and 3 moderate to fairly progressive Democratic appointees. And on most things that are highly politically charged and they come down on a division, it's a 6-3 thing. But every once in a while, you'll have some variation, some combination of Chief Justice Roberts and Justices Kavanaugh and Justice Barrett siding with the 3 Democratic appointees to either say, Fifth Circuit, you are being too crazy, that get out of here, or to manage expectations of a Republican Party that wants them to go faster than they're willing to go. But in this case, it seemed as though at oral argument, Kavanaugh, Barrett, and Roberts seemed uncomfortable with this idea that a woman could potentially lose her reproductive capacity and seriously have serious health issues for the rest of her life, and even need to be airlifted, as had been shown to the court, airlifted out of Idaho to get emergency abortion services under this ban. So what those three tried to say at oral argument was, no, maybe Idaho's ban isn't as severe as it reads to be, and maybe the exceptions or the requirements that are provided under federal law for pregnant patients to obtain abortions aren't as expansive as we thought they could be. Maybe these things actually aren't in conflict, but actually are coextensive. And that seemed to be what those three wanted to say this case was about. The problem is they could not get any of the other six on their side. You had their three Republican colleagues, Justices Thomas, Alito, and Gorsuch, saying that EMTALA does not allow for abortion as medical care, and the states never signed up to condition their Medicare funding on their providing abortion care in emergency settings, such as what EMTALA requires. So therefore, there is no conflict, and women and pregnant patients going into emergency rooms in Idaho who aren't at death's doorstep are out of luck, and they have to be airlifted out. So be it. That's what the people of Idaho wanted. That's what those three wanted to say. And the three Democratic appointees, Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, said no. EMTALA clearly overrides the state law because EMTALA clearly applies to pregnant patients who need stabilizing abortion care when they come to a hospital that with health and with deep health threatening conditions, short of being on death's door. So those three camps could not come together, and it seemed as though there was a tug of war between the left flank and the hard right flank for the rest of the right flank, and no one blinked. And when no one blinks, you cannot get a majority, and without a majority, the court cannot come to a decision. So what you had today was the court saying, "We give up. We can't reach a final decision on this. So we're going to," what you said before, Ben, dig the case, dismiss it as improvidently granted. We should have never taken it in the first place. We short-circuited the appeal process. The Ninth Circuit was still considering whether there was a conflict here at all. We're going to send it back to them and have them consider it, and we're just going to get out of this. So the court was 5-4 on that, because Justice Jackson joined for different reasons, joined Alito, Thomas, and Gorsuch to say, no, we should have taken this case and decided it right now. The answer is clear. It's easy. And people and pregnant patients and people around this country, and Idahoans and Texans too, for whom this also applies, they deserve an answer from us, win or lose. But it was a 6-3 vote with the three Democrats and Roberts, Barrett, and Kavanaugh agreeing to let EMTALA go into effect, let emergency rooms in Idaho provide EMTALA required care to patients who come in there needing it. So we're back to the state of affairs from when the district court first blocked Idaho from enforcing its ban against emergency rooms in Idaho. And this was a 6-3 case on that issue. So now we're back to square one with this case in lower courts, trying to decide to get a final answer on what this conflict is. And it's going to come back up to the Supreme Court. And there's some other issues in Barrett's concurrence that I can expand upon further on what might happen if and when this case does get back to the Supreme Court.
So the headline, this is Bloomberg's headline, so I'll just use it, is United States Supreme Court poised to allow emergency abortions in Idaho. Opinion was briefly posted on the court's website and removed. Hospitals would be allowed to protect pregnant mothers' health. While that's the headline, Mike, as you break it down, it's actually far more complex than that. The far right-wing justices are saying, we don't really care what EMTALA says. The state here passed the law. If a woman's about to die, they're going to have to prove that, like, they are literally knocking on death's door. Yeah. Maybe they can get it, but otherwise we're okay with a woman who needs abortion care to save her life basically dying because that's what Idaho wanted. That's what they're saying. You then had the 3 Democratic judges saying, what are you talking about? EMTALA is a federal law. There is the supremacy clause. Federal law trumps, no pun intended, state law. And women have a right to emergency care. And if abortion is the standard of care for emergencies, emergency medical treatment is EMTALA. Federal law clearly applies. And then you had the other right-wing justices who you mentioned, though, that other 3 were trying to negotiate this balance and say, well, we definitely think that there's the states' rights that are important, but that's not necessarily in conflict with EMTALA. We don't have to get to the overall issue there. And they were trying to be too cute by half. And that's where Ketanji Brown Jackson said, you may, she didn't say these specific words. I'm paraphrasing her. Then I'll give you her specific words. This may be announced as a victory because EMTALA remains the law of the land for abortion care. But what she says specifically is today's decision's not a victory for pregnant patients in Idaho. It's just a delay. While this court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position as their doctors are kept in the dark about what the law requires. So Ketanji Brown Jackson, this is an easy one. I want to hear it now.
Yeah, and there's strategy going on behind the scenes here. And even though Jackson said that they should decide this case now, by virtue of the liberals not blinking on this and not saying, okay, fine, we'll join this compromise that you're trying to conjure up, Justice Barrett, and we'll pretend as though the Idaho law isn't really in conflict with EMTALA. No one bought that except for the 3 justices who were trying to mangle text to make that happen. No one. It just wasn't going to happen. So what ended up going on was by not blinking, the liberal justices, the Democratic appointed justices, they ended up getting a short-term win, which for Sotomayor and Kagan was good enough, right? Just to make sure that any disaster was averted, to make sure that Barrett, Kavanaugh, and Roberts did not go back into the fold with Alito, Thomas, and Gorsuch. Disaster was averted for pregnant patients in Idaho and in Texas as well, where there's a live issue about this conflict as well with their ban of abortion. And for Kagan and for Sotomayor, that was good enough. For Jackson, this continued state of uncertainty of the law, even though in practice EMTALA still applies, was untenable. And again, this is going to come back to the court. And Barrett, in her concurrence, gave a roadmap for Idaho on how to win upon coming back to the court, on how Barrett, Kavanaugh, and Roberts would rejoin the fold. And she said that on when the case goes back to the lower courts, Idaho should argue that Congress is not authorized to condition federal funds on a state violating its own criminal laws. And that's actually a pretty profound question. This is a spending clause question, and the right-wing legal movement and the members the Republican appointees on this court have long been at war with Congress's broad power to get states to expand Medicare, Medicaid, extend Social Security, because they think that violates states' rights. Congress has the broad power to make those conditions, but they've been chipped away by the right wing of this court for several decades now. And this is another argument that Barrett is saying she will buy, and Kavanaugh and Roberts also sign on to this, that will further chip away at Congress's power to achieve national policy in the states through its power of dispersing federal funds. Because right now, EMTALA applies to hospitals that take Medicare funding. If hospitals take Medicare funding, then they have to do as EMTALA demands. And what Barrett is saying, Idaho should argue, is that Idaho should say no, not if what EMTALA commands makes us violate our state criminalization of abortion. So this comes back up to the court. You'll very well see the 6 Republican justices reunited and going against EMTALA and for Idaho in a much broader decision that will chip away at Congress's power to effectuate national policy. So, as Jackson might have actually given her piece today because she saw the writing on the wall, and a decision even against the federal government, even a decision for Idaho on the issue presented to them in this particular round would have been less damaging for congressional power than what might come up next.
So in addition to working at Court Accountability and now being a MeidasTouch correspondent on law politics with a specialty in the Supreme Court, Mike and I went to Georgetown Law together about 15 years ago. And so to fast forward about 15 or so years later, where we could really geek out and not just give you the sound bites that you're getting elsewhere, but to really go into what these issues are about and to know how smart this audience is and give you the real data that underlies this is something that Mike and I take a great deal of pleasure in being able to deliver that to you uniquely here on the MeidasTouch Network. You're going to be seeing a lot more of Mike Sachs on the MeidasTouch Network, and it's great to have you. And of course, Meidas Mighty, it's great to have all of you watch us. Let's get to 3 million subscribers this summer. Hit subscribe. We're almost there, and have a wonderful day, everybody.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.